Alrighty, good morning. We're gonna have our first attempt at trying to record some information for you guys. We'll see how it goes. Hopefully, everything is easy to hear. There's no confusion surrounding that. I know the audio quality probably isn't going to be the best. I'll continue to work the kinks out on that. But with that in mind, here's our walkthrough of your cases, and I'll provide you guys a copy of these combined slides as well, so you can look through them if you feel so inclined. The cases that we're going to go through are going to go in order of your bracket, starting on the right and working our way down, and then we'll work our way up from the left. So our first case is McCulloch v. Maryland, and this is Peyton's slides. So as Peyton explains here, the issue with McCulloch v. Maryland is that the Second Bank of the United States was chartered in 1816. 2 years later, in 1818, Maryland imposed a tax on the bank. The reason Maryland did this is because at the time we still had issues between the idea of states' rights and federal rights, and Maryland felt like it was a violation of their states' rights to have a bank built by the federal government in their state. The reasoning for this is because then it's going to compete with state banks and they're going to be less successful, especially because states have less money than the federal government. So the Maryland government's like, well, if you're going to do this, we're going to tax you. We're going to get some money out of it. The worker at the bank by the name of James W. McCulloch refused to pay that tax. And this is kind of what started the whole case. It was then taken to court because Maryland wanted to pay. He refused, and so someone had to settle it. The ruling of the Supreme Court was that Maryland could not tax the bank because it was under congressional control. And on top of that, they also ruled the fact that Congress could make the bank. Their reasoning was due to the necessary and proper clause, the idea that in order for Congress to carry out its powers, specifically the power of controlling and regulating commerce, they needed to have banks. Banks are necessary to run commerce because you need to have somewhere to put your money that you're going to loan out to small businesses and use to encourage trade and all things like that. They also ruled that Congress cannot be taxed by a state because that's just a violation of the entire system. A child cannot give their parent an allowance or ask them to pay taxes. Like, that just doesn't make sense. It's usually the other way around. And the significance of this one is, first and foremost, like Peyton says, it's putting Maryland back in their place, establishing the dominance of the federal government over the states, but also it gives a kind of guideline for what's states can and cannot do when it comes to taxation. And also, very importantly, to add to what Peyton has, is that it's extremely important because it establishes that the necessary and proper clause can be very flexible. This came right after the whole debate between the followers of Thomas Jefferson and Alexander Hamilton, and the idea of what is acceptable for the federal government to do and what is not. Do we have a strict interpretation of the Constitution or a loose one? And this sets a precedent for a very loose interpretation of the Constitution, because commerce and banks, they're kind of loosely connected, but not as much as you would necessarily like. And that's only going to continue going forward with other Supreme Court cases. So to reiterate, it's important because federal government is on top. There's clear guidelines for states on taxation, and it creates a lot of flexibility with Congress's powers. So then that brings us to Tinker v. Des Moines, and this one's by Gideon. So as Gideon states, this one's situation is pretty straightforward. There are a group of students that wanted to wear black armbands in support of a truce in the Vietnam War, so protest in the Vietnam War. 2 students wore their armbands to school and then were immediately sent home by the administration. Administration said, no, you cannot wear those, you cannot protest. And the kids are not allowed to return to school after New Year's, and they are not allowed to have their protest as a result. The students complained that their freedom of speech was being violated, that the educational administration was saying you cannot say or think whatever you would like, and that's a violation of their rights as a citizen. The Supreme Court ruled 7-2 in favor of the students, stating that the First Amendment right does not go away when you enter the school building. While there are lots of rights that you forfeit by entering into school, just like when you enter into the workplace, your freedom of speech is not one of them. And so school officials have to prove that the students interpreted how the school was being run. The effect of this is that the free speech is allowed in public schools unless there's clear evidence that it's affecting the educational process. So you can say and do a lot as long as it does not actively take away from the learning experience. So in their instance, right, it's just something that they're wearing. It's a black armband. It doesn't cause any major distractions. However, if you went around and started shouting racial slurs all the time, like that is a distraction disruptive. Therefore, it's not allowed. That's not protected free speech. And from there, we go to Engel v. Vitale. So in this instance, what had happened is the New York State Board of Regents had authorized a short voluntary prayer at the start of each school day. A group, however, challenged the prayer, claiming that it violated the Establishment Clause of the First Amendment. What the Establishment Clause does is it prevents Congress from passing legislation forcing an establishment of religion. So it prevents anyone from being forced to practice any one particular religion. It gets back to that idea of freedom of speech, and in particular, preventing governments from doing it. And it also prohibits the government from preventing the free exercise of religion. So if you want to go and pray traditionally in the Christian method, that's fine. But also if you want to, meditate, or if you have an interest in praying towards Mecca, as is the Islamic practice, all of that has to be allowed. The Supreme Court ruled in favor of the group that said that a prayer should not be led in school due to the Establishment Clause, because schools are publicly run. They are run by the government. And so for the New York Board of Education to create a time for a prayer, even if it's voluntary, is still an example of them trying to force a religion in the eyes of the Supreme Court. They said that you are taking this time out of the day, you are making it specifically for prayer. Yes, people don't have to volunteer for it, but you didn't also make a time, for meditation, or for the prayer facing Mecca, or for all of these other different religions. It's favoring one over the other. And so even though it's voluntary, it still violates that Establishment Clause. And so this is significant because it reinforces the power of the First Amendment. It helps define what exactly is and is not allowed by the First Amendment. And most importantly, it continues to emphasize the fact that religion and government are two separate things. The idea that if anything is controlled or run by the government, then it cannot have a religious component, and that includes schools. So this brings us to Shaw v. Reno. So in this one, North Carolina had tried to redistrict, and this time they wanted to do it in a way that they had only one black majority district. The plan got rejected, so North Carolina submitted another plan with two black majority districts. Of the two districts, one was very small in places, and it was oddly shaped, traditional gerrymandering stuff. 5 North Carolina residents claimed this was unconstitutional because they thought its only purpose was to obtain the election of additional black representatives. They felt as if the redistricting was done due to racial reasons, so trying to forward the benefits of the African American community. The Supreme Court had to think about this one. It was a dicey ruling, but they came up with a 5-4 ruling, and they concluded that North Carolina was in fact guilty of redistricting based off of racial reasons. Specifically, their justification was the oddness of the shape and how it was small in some areas. It was clear that there was no practical reason for that shape other than if you are trying to get a predominantly African American district, which is not acceptable. Again, just kind of restating what I said there, because of the weird and absurd shape. There's no other reason. And so this is significant, as Drew states, to U.S. history, as gerrymandering is a common thing to do to favor one specific party, and it served the purpose to show that it is not okay to redistrict based off of racial reasons. So putting some caps on gerrymandering. It also goes to show that just because your districting is neutral, you still cannot group the same races all together and call your districts equal. proved that racial gerrymandering violates the 14th Amendment, which guarantees all citizens equal protection of the law. So that brings us to Gideon v. Wainwright. In this one, now these are ones that I did to just kind of quickly summarize them, as nobody had them for your class, but they're still on your brackets just to make sure it's kind of even. So with Gideon v. Wainwright, the issue is that we have Clarence Earl Gideon, who gets charged with breaking and entering in Florida. When he goes to the court case, he cannot afford a lawyer, so he asks the Florida court to appoint him a lawyer, as is protected under the Bill of Rights. The state, however, refused to give him one because under local Florida law, they had decided that for efficiency's sake, the court would only appoint lawyers in high-level cases, so like capital punishment ones where the death penalty is involved. If it's just prison sentences, then they're like, no, it's not that bad, you can just suck it up. He complained and argued that the Sixth Amendment entitles Americans the right to legal counsel, no matter what. The question, however, was if that extended to state courts. So it doesn't explicitly state if the Sixth Amendment is referring to the federal court system or the state court system. And so does this apply, or is it only if it's a federal crime? And what justices ended up ruling was 9-0 in favor of Gideon. And they stated that the right to a lawyer is given by the Sixth Amendment, and because it's not specific, it applies no matter what. It is a universal right, and that is further protected by the 14th Amendment, which states that states cannot violate citizens' rights. And so this was significant because, one, it further asserts the federal government's influence over states by making it so that states cannot make their own laws to circumnavigate the Bill of Rights. And it also further protects the rights of citizens from legal loopholes that would prevent you from having a fair trial, a recurring issue in particular during the Civil Rights Movement era, where African Americans were consistently jailed for unjust reasons. This one further saying, no, you can't just lock somebody up. They have to have a fair trial. So that brings us to Roe v. Wade. In this one, it's 1960, and there's an individual named Jane Roe. It was a fake name in order to protect her identity because there's, as is today, abortion is just a really hot topic. And what she was doing was, in fact, challenging abortion laws in Texas. Texas had made it illegal to obtain an abortion no matter what, except if a doctor specifically stated it was necessary to save a woman's life. So if like the mom was going to die as part of the pregnancy, then an abortion would be acceptable. Otherwise, no deal. Roe argued that this law was not only vague, but it violated her right to personal privacy by forcing restrictions on what she could do with her body. So you know, similar to how privacy laws protect what happens in your own home, she argued that privacy laws also protect what happens inside her own body and what she does with her body. And in particular, she pointed to the First, Fourth, Fifth, Ninth, and 14th Amendments and the various ways that they protect the citizens' rights to privacy. And so the question was, does the Constitution recognize abortion as a right? Does this actually qualify as part of your privacy, what you do with your body? And justices voted 7-2 in favor of Jane Roe. Their argument for why it was acceptable for abortions, it was that the 14th Amendment in particular has a right to privacy clause, and they agreed with the idea that what you do with your body is your own private decision. It cannot be decided by some outward force, with the exception, however, that it is balanced against the fact that the government has a responsibility to protect the lives of humans and the potentiality of human life. So they also have the right to say, well, you know, you can do whatever you want with yourself to a degree until it starts to threaten others. And if that other is potentially a newborn human, then they can step in and actually have regulations. And this case is significant because, one, it creates a very broad precedent for what is interpreted or considered as an individual's privacy. Previously, we'd always considered it as just, you know, what you say or do inside your home, whether you decide to, you know, just collect a lot of old newspapers, if you decide to be a hoarder, if you decide to be an alcoholic in your own home, all of those are things that you get to do because it's your right as privacy. This is the first time we're saying also what you do with your actual body is up to you. And so this kind of deals with the whole idea of vaccinations later on. Is actually part of the debate surrounding that today. But also on top of that, it creates a controversial situation where because it doesn't clearly state when a fetus is considered a human life, just that you have to consider a human life, it has the debate today where like, okay, when is a baby considered a human? Is it life at conception? Is it at 3 months, 4 months, 8 months? Like, where is this line? And so we have a lot of debate around this case today because there is not a clear decision, and it leaves a lot of room for interpretation. It's why you hear in the news a lot right now because of what else is going on, but like Ohio and Kentucky and other states had recently passed laws about the fetal heartbeat. This idea, well, okay, there's a fetal heartbeat, that's a sign that it's alive, that's a sign that it's a human life, and so you cannot get any abortion before that, and that's oftentimes before a woman even knows that they are pregnant. So a whole bunch of legal confusion surrounding it as a result of this ruling. From there, Shank v. US. And this one, there's an issue during World War I. There's a socialist named Charles Shank who opposed World War I, and so he went around passing out leaflets opposing the draft. And on the leaflets encouraged citizens to reject the draft, tear up their cards, burn them, refuse to go and serve the nation. And he was arrested for this. The government stepped in and said, nope, can't be doing that, off to prison you go. And their reasoning was that he was obstructing recruitment and threatening the war effort as a result, because if you can't get enough soldiers, you can't really fight the war. Shank, on the other hand, argued that his freedom of speech was being violated, his First Amendment right. So the question on the table was, did Shank's arrest for criticizing the draft actually violate his freedom of speech? The justices ruled actually in opposition to Shank with a 9-0 ruling in favor of the United States. So restricting his freedom of speech, saying that nope, his rights were not violated. And their reasoning was that during wartime, the government has greater powers, and in particular, they have greater powers even when it means violating rights. And when it comes to freedom of speech, they argued that there has always been, since the very beginning, there's been the check for a clear and present danger. The idea that you cannot run into a crowded movie theater and shout fire, because that creates a clear and present danger to the people there, because they might panic, they might trample one another as they try and get out of the theater. They argued, the Supreme Court, that Shank presented a clear and present danger to the war effort because his actions were actively getting people to not support the war effort, and that could be dangerous to soldiers out in the field or at home if they cannot get the support that they need. And this one is significant because it's one of the first times ever that we see freedom of speech being restricted by the Supreme Court rather than being protected. And more importantly, it sets the precedent that the government is the organization that gets to decide at the end of the day what constitutes a clear and present danger. And much like how the necessary and proper clause creates a lot of room for interpretation, what is a clear and present danger is extremely open to interpretation. There's not a list there at all. It's really, can they create a persuasive enough argument that this is dangerous for the people of America? And so it sets kind of a concerning precedent that we see pop up off and on. From here, we go to Citizens United v. the FEC, and as Tyler seems to think, the most influential decision in Supreme Court history. So this one is between the Citizens United petitioner and the Federal Election Commission respondent. The Federal Election Commission is there to make sure that when we're having elections, we're not violating any sort of laws or doing anything shady. So what you need to know, Citizens United was looking for an injunction against the FEC. And what they were concerned about is that it was preventing the application of the BCRA in their movie. And in this movie that Citizens United was trying to present is that they wanted to share opinions on President Clinton, not Hillary Clinton, as she did not win the election. and this is long before that as well. And what Citizens United argued was that sections 203 and 201 were unconstitutional, and specifically, these dealt with the idea of what exactly a citizens group was allowed to do in elections. The BCRA, to be specific, is the Partisan Campaign Reform Act, and it regulates financing of political campaigns. Chief sponsors were Russ Feingold and John McCain, and it basically stated that corporations, labor unions, large organized groups of citizens cannot fund electioneering communications. And electioneering communications constitute anything where you're trying to convince somebody to support one candidate over another or to dislike another. So like this one, their movie that they were trying to make was against President Clinton. It actively opposed him, and it was funded by this large group of individuals who had come together and pooled their money to create the film. And they were not being allowed to do that because they had put regulations on how much you are allowed to contribute. The idea behind the BCRA was that you don't want a lot of money from large corporations because a corporation or a labor union inherently has more money to throw at something than the average individual. And so they can use that money to persuade a lot more people, and they're kind of abusing their position as this wealthy organization. The main question then was, should a feature-length documentary about a candidate be subject to regulation under the BCRA? And in particular, if a communication lacks a clear position on a candidate, is it subject to regulation by the BCRA? And so like the issue there was the film didn't outright say to vote for or against Clinton. It just kind of implied how you should think. The decision, which was a close one, was 5-4 in favor of Citizens United, the organized group opposing the candidate. And this is very significant to elections today in that it's the First Amendment protects the freedom of speech despite the speaker's corporate identity. So one, saying that freedom of speech expands beyond just an individual, but to larger groups. It further states that funding independent political broadcasts cannot be limited, and since the film wasn't from any specific party, the funding was allowed. And so what this translates to today is that large organizations, and as we saw in a documentary earlier this semester when we were talking about the presidential elections, is that large organizations now can pool money and campaign for candidates as long as they're not, directly telling you who to vote for. They're just kind of implying it. It creates a situation today where you see big money. And so any organization that has a lot of money has a lot of influence in political campaigns and can really adjust how you act and think by just drowning you in media that supports one candidate or another. An excellent example of this sort of tactic, while he wasn't a large organization, if you guys think about Bloomberg when he was running for the Democratic nomination, and on YouTube it was like every other ad was Michael Bloomberg being up in your face saying, hey, vote for me. It's like that, except a corporation can do it now, not just an individual. So like McDonald's, if they wanted to, could throw a bunch of money at ads and drown YouTube in them, as long as they didn't specifically say vote one way or another. And so it creates very dicey situations surrounding our elections. So that's the right half of our candidates for the SCOTUS Sweet 16. From here, we'll go ahead and run up the left half. I know I've been talking for a while. I'm sure this is not really what you wanted to listen to, and many of you will look through the slides, but I also want to make sure that this was available to you just in case. So, Wisconsin v. Yoder. Here we go. Case is about compulsory school attendance law, and in particular, the idea that it was unconstitutional when applied to the Amish. So, we had a situation where there was an Amish family that did not want to send their kids to public school because they wanted to homeschool them, as is often an Amish tradition. The school said that no, they had to send them because there was a law and they were required to follow the law. The Amish argued that it violated their First Amendment right, which guaranteed them the free exercise of religion. And according to their religion, their kids should be homeschooled. The Supreme Court ruled on May 15th of 1972 that 7-9. They ruled should have been 7-2, I believe, that the Wisconsin school attendance law was unconstitutional when it applied to the Amish. And the reasoning behind this and the significance, we'll get to both. The reasoning was that the Amish individuals were entitled to their religion. If their religion stated that they did not have to send their kids to school, to force them to have their kids attend would be a violation of their rights. The only detail that had to be followed was that as long as the Amish could show that their kids were receiving the same quality of education, then there was no problem. So as long as, when they took high school level tests or when they today take things like the SAT, ACT, as long as they can demonstrate that they meet the same amount of achievement as the public school, then they're good to go. They are allowed to keep their kids out of school because of their religious beliefs. And so this is an example of the First Amendment rights being further reinforced for our citizens, where you now can actively ignore other state laws as long as it's under this freedom of religion. You can also see this in vaccines today. It's a similar comparison. It's been used to justify as well the fact that you can be exempt from vaccines for religious reasons, because again, as long as you are providing that the kid meets the same health requirements, then religion takes precedent due to the First Amendment. Next up is New York Times v. Sullivan. So what had happened in this particular case is that the New York Times had published an ad for donations to defend Martin Luther King Jr. on charges of perjury. So he'd been arrested and was being held for lying under oath, and they were trying to raise funds to support him. The issue was that in the ad, they described Sullivan, who was a police commissioner at the time, and reported facts that were inaccurate about Sullivan. So they said that he had been cruel or mistreated Martin Luther King and many of his supporters, despite the fact that it had not actually taken place. Most importantly, they also do not directly mention him. They simply refer to the police commissioner. So Sullivan got real salty. He felt that the criticisms had been reflected on him and were spreading false information about himself. So Sullivan sent a request to the Times asking them to remove the information. The Times said, nope, we're going to keep the ad up. We're going to run this because we believe that these are the facts. Sullivan then decides to sue the New York Times for printing something that they knew was false, which is a libel law, which is an aspect of the First Amendment that you cannot violate. The Times and Sullivan then go to the Supreme Court to deal with the situation. The Supreme Court ruled in a unanimous decision in favor of the New York Times. The reasoning was that the only way you can prove libel is if you have hard evidence that the newspaper knew that the information was false. So unless you can outright prove with like a recording where they're all sitting around the news desk saying, all right, let's print these lies to make Sullivan look bad, then they're allowed to do it because mistakes happen. People get bad information and they shouldn't have to be punished for that. They're not going to restrict the freedom of speech because someone might have made a mistake. And so from here, you now have these very strict expectations for what exactly is considered libel. And as Braden defines it, libel is a published false statement that is damaging to a person's reputation. In this case, significance stems from the fact that it protects the press and the public's rights to criticize officials in the conduct of their duties. So now, elected officials, due to this one, cannot complain when someone prints false information about them unless they can prove that it was blatantly false. It's kind of how we get to this issue of fake news, where news organizations can print whatever they want as long as they can make sure that they didn't make any mistake where it's clear that they're doing it to hurt others. It also rules that the freedom of speech protections in the First Amendment to the U.S. Constitution restrict the ability of American public officials to sue for defamation. So you kind of give up some of your freedom of speech as you move into the public eye based off of this case. Next up, United States v. Lopez. So in this one, Alfonso Lopez was a high school senior who carried a concealed weapon into his San Antonio, Texas high school. And he ends up getting charged under Texas law with firearm possession on a school premises. But the very next day, the state charges were dismissed, and he instead was hit with federal charges. They charged Lopez with violating a federal crime statute, which stated that there cannot be guns in school zones, and it had been one that was around from 1990. And he was originally found guilty of violating the federal law and sentenced to 6 months imprisonment and 2 years supervised release. However, this all ends up getting dropped. So to add a little context to this particular ruling, what had happened, and this one's kind of a confusing one, is that with the restrictions under the federal ruling, they had come up with this decision because, according to the federal government, the restriction of access to firearms in the schools was part of the necessary and proper clause for regulation of commerce. They had argued that in order to make sure that they're keeping eyes on what is sold and bought, in particularly the firearm realm, they were going to restrict access to firearms in the school zone. The Supreme Court ruled that that's ridiculous. That's not an economic regulation. Like, you cannot prohibit firearms in the school under the guise of trying to arm their regulation. They ruled that if you wanted to pass a different law that had something to do actually with safety, security, something along those lines, yes, that's fine. But this one was an overstepping of the boundaries of the necessary and proper clause, and that it was not going to be allowed. And so this one is significant because it's one of the very first times that Congress actually gets ruled against. If you think about the previous cases we've talked about, consistently the Supreme Court says necessary and proper clause is okay. The amendments and the Constitution are extremely flexible. This is one of the only times where Congress is actually reeled back in and the Supreme Court says, no, 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 that's too flexible. You can't just fit anything and everything into the necessary and proper clause. So one of the few times we're actually reeling in the government, demonstrating that we do actually have this nice balance. The checks and balances do work. It's not that the Supreme Court always sides with Congress. Sometimes they turn against them. All right, so moving on, we've got Brown v. Board of Education. So this one is about segregation. Should hopefully be relatively familiar. And in particular, it deals with the idea that African Americans are not being allowed to go to white schools, and it was seen as a violation of their rights because it was not an equal education system. In this particular case, the Supreme Court ruled that it was unconstitutional to segregate schools. The reasoning was that under the 14th Amendment, everybody is given equal protection under the law, equal rights. You should not be denied any. And under their logic, because they were separate, they were inherently not equal. Even though originally the idea was that separate but equal, if you separate people and you give them two different areas, you are inherently demeaning one group over the other. There's no way of getting around that. And so as a result, they cannot have separate schools, and integration must be forced. And so this is significant not only because, it ends segregation, but it also sets the precedent going forward for the Civil Rights Act. The idea that, well, if separate but equal is inherently bad in schools, then that must be the same case for drinking fountains, for train cars, for bathrooms. Like, one is no different than the other. If any form of separation is inherently unequal, then all forms of separation must be unequal. All right. McDonald's v. Chicago, almost done, 3 left. So this case has to deal with the Second Amendment and whether or not it applies to states. And it specifically is in response to gun bans in Oak Park, Chicago. What had happened is that Chicago had outright banned the ownership of firearms, specifically handguns in Oak Park. Like, can't do it, not allowed whatsoever. The individual had argued that, of course, that was a violation of their Second Amendment right, McDonald, And when it went to the Supreme Court, the ruling was that the Second Amendment applied to states under self-defense, and they argued that it is fundamental to the liberty of our country and that it is a tradition that is deeply rooted in America. And to just kind of expand upon this, what had taken place was that the state had argued that the Second Amendment was a right, yes, however, it was one that could be regulated at the state level. It was not a federal mandate. And so if the state wanted to put their own exceptions on the Second Amendment, they're allowed to do so. And so they could, in theory, argue that, well, only certain individuals, they could interpret it however they wanted to. So if they said that, well, police and military are the only ones under the Second Amendment that actually get to have firearms, because that's how we read it, then we're allowed to do that. In this case, and this ruling says no. It is a federal application. So while you can set different rules for acquiring a handgun, you cannot outright get rid of it. You cannot decide who gets access to firearms. That is one that the federal government supersedes. And so this is super significant because it continues to enforce the federal government on the states, and in particular protect gun rights in this instance, where over and over and over again, just because a state thinks that they can interpret something on their own, that's not the case. At the end of the day, the federal government has the final say, and the federal government decides that the Second Amendment applies to everybody. And so it affects all of our nations because it, or sorry, not all of our nations, all of our states, because it outright prohibits a ban on guns, and that's universal now. And so that's why no matter where you go in the United States, you can always purchase a firearm. It's just that the rules to acquire one are slightly different. So it brings us to Baker v. Carr. And so this one, the issue is that Charles Baker in 1901, we got another redistricting issue. He argued that the redistricting laws for Tennessee's General Assembly were ignored. And in particular, he argued that redistricting had not appropriately given seats to areas of economic growth and population growth. So again, just not redistricting appropriately. So the overall question then was, does the Supreme Court have the right to step in this issue? Because it's a state internal issue. It's their own problem. Can the Supreme Court act as a governing force when it's all internal and all state government based? And the justices voted 6-2 in favor of Baker. One justice sat out, Justice Whitaker, and his reasoning was because it stressed him out too much. The guy legitimately said, you know, I am having health issues because this is such a big decision and I just don't feel comfortable. And so he recused himself. And their justification for this ruling was that there are plenty of times before in the U.S. history where their Supreme Court had stepped in to make sure that state governments were not violating the Constitution. And in this instance, they argued that yet again, the Constitution was involved, even though it was a state matter, because the 14th Amendment protects equally all citizens of the United States, both in their treatment and in their representation in government. And so if a state government is redistricting poorly, even for their own state representatives, that still is the federal government's business because they have to make sure that their citizens' rights are being protected. And this one is significant because it, again, further expands the influence of the federal government and the Supreme Court over states. Over and over again, many of these cases create this situation where the federal government is on top, the states are subservient. And so this brings us to our last case, Marbury v. Madison. So with this one, what happened is before Jefferson takes office on March 4th, 1801, previous President Adams and Congress passed the Judiciary Act of 1801, which created new courts, added judges, and gave the president more control over the appointment of judges. And then Adams decides to use this to appoint 16 new circuit judges and 42 new justices of the peace in order to cause problems for Jefferson. The two hated each other, and so Adams is like, fine, I lost the election, but you have to deal with all of these people who are going to interpret laws the way I would want them interpreted rather than you. And so over and over again, they're going to rule against you. The appointees get approved by the Senate, as is the system, but they would not officially take their jobs until they received their commissions, which were little pieces of paper that explicitly stated, you are now a circuit judge of the United States, or you are now a justice of the peace of the United States. And these have to be delivered by the Secretary of the State. William Marbury is one of these people who had been appointed. He was going to be a justice of the peace in the District of Columbia. However, Adams left office, and so Jefferson and Madison refused to give him his commission. They don't hand it to him. Marbury then goes to Madison, the Secretary of State, and says, I would like my commission, please. And he says, no, I'm not going to give it to you. Go away. We don't want you. And so Marbury petitions the Supreme Court to force James Madison to give him the documents. He basically says, look, man, the previous president gave me this position. It was approved by the Senate. It has followed all of the appropriate governing rules. You need to follow through with this. And he had refused over and over again. And so a number of other appointees all petition the Supreme Court to force them to deliver these commissions. And what ends up happening is that the Supreme Court finds that Madison's refusal to deliver the commissions is in fact illegal. Like, he does need to give them their positions because they went through the appropriate process. However, they do not order him to hand over the commissions. So they do not step in and force him to do it. Their reasoning being that the court's overall decision on the act enabling Marbury to bring his claim to the Supreme Court to begin with was unconstitutional, since it created this situation where the court's original jurisdiction was beyond that which had been originally laid out in the Constitution. So you get a weird kind of dual decision where the court on the one hand says, yes, this is wrong. However, we can't force him to give them to you because that's outside of what the Constitution has said we can do. They, from here, are put in a position where it creates the basis for how the how the Supreme Court is going to work going forward. And so what they decide is that, or what they decide creates the idea, one, of judicial review, where the Supreme Court has the authority to find something unconstitutional, but it also situates them in a place where they are not an all-powerful entity. It does not create a court that can force anyone to do anything. They cannot override entirely any one branch of government, simply act as a check to make sure that they are held in the correct position and that no one oversteps their boundaries. So that's it. Those are all of the Supreme Court cases on your Sweet 16 bracket. So either today or tomorrow, what I'll need you to do now is just go through that bracket and complete it like you would any normal bracket. So you'll just decide which case you think is more important in each of the matchups based off of what took place. While you're doing that, please be paying attention and thinking about their larger applications. So obviously each of these has an immediate event that's rather significant, but also it's important to think about long term. So how these cases might affect us today, because all of these cases in some way, shape, or form influence how you live your life as an American citizen today. And so you'll just complete the bracket with that in mind and ultimately decide what you think is the most significant Supreme Court decision, which one has had the biggest and most lasting impact on our society today. Thanks for listening. If you did, hopefully it wasn't too painful, and I hope you have a wonderful rest of your day.